Deki Panjiyara was a Shashi Bushan, Ryan and another, where the court held that mere production of marriage certificate was not sufficient to render a complete and effective decision with regard to marital status. Consider the application herein and the responses. Together with 6 of the Marriage Act 2014 states, and I quote, a marriage may be registered under this act if it is registered A, in accordance with the rites of a Christian denomination, B, as a civil marriage, C, in accordance with the customary rights relating to any of the communities in Kenya, D, in accordance with the Hindu rites and ceremonies, and E, in accordance to Islamic law. Subsection 2 states that a Christian, Hindu, or civil marriage is monogamous. Section 9 of the Act prohibits a married person in a monogamous marriage to contract another marriage. The applicant has produced a certificate of marriage and a marriage certification form as proof that 2018, while the certified copy of the certificate of marriage appearing at page 20 of the bundle of documents is also dated 28 December 2018. It's dated 28 December 2018. These documents were obtained a few days after the petition hearing was filed on 17 December 2018. The authenticity of the said document has been challenged by the respondent hearing. It is important, therefore, interrogate this challenge or issue, and it's my humble view that for there to be a certification for the certified copy of the marriage, it is either that the original copy is missing, or a party now seeks to have a copy held by the registrar of marriage and issued to him. The signatures appearing on the marriage record in page 18 of the applicant's bundle, and that on the supporting affidavit appended by the applicant in his affidavit, in my view, are glaringly different, and this gives credence to the argument that the respondent that the certificate has some discrepancies. The certified copy of the certificate has a provision to have the name of the person who typed the certificate appear thereon, and also the one who checked. These details are conspicuously missing from the certified copy, and it is not known who appended his signatures thereon. Part 5 of the Evidence Act deals with the presumptions to documents. Section 83(1) of the said Act states, and I quote, a court shall presume to be genuine every document purporting to be a certified copy or other document when A, declared by law to be admissible as to evidence of any particular fact, B, substantially in the form and purporting to be executed in a manner directed by law in that behalf, duly certified by a public officer. Certified has a due two families met. The affidavit sworn by Joseph Kitany. Mind is whether with the observation made by this court in regard to the omissions made in the certified copy of the marriage certificate and the contents of the marriage certification form, so as to make a finding conclusively. Company Limited versus Joseph Mbaria Mushina. The Court of Appeal had this to say on the issue of striking out, and it held that no suit ought to be summarily dismissed unless it appears to be so hopeless that it plainly and obviously discloses no reasonable course of action, and is so weak that as to be beyond redemption. The court in that decision has set out a very look out to there being a semblance of a course of action which can not to strike out the suit. Striking out Cooperative Merchant Bank Limited by the John Frederick Wakesa, where the court held in this is Dracodia as a Dracodia now. The court has to determine whether this case is plain. In this case, I find and hold that this matter should be set down for full hearing by way of viva voce evidence, so that the same can be tested or cross-examination. To that extent, then, I proceed to dismiss this application with no orders to cause, and order that this matter be listed for hearing, for full hearing on private basis. This is the matter of the court.
We instruct and request, given the nature of the hardship, which of course that the other side might want to tell you we need to do this. The order of suggest is, or rather the direction of suggest is as follows. The subject to ordinary, the parties should file their respective witness statements if they have not done so, if they will be able, and that we get a hearing subject to the court's convenience in 14 days month, so that in short I'm suggesting if it finds favor with the court, that if any of the parties needs to file any witness or document or witness statement, whatever compliance the party might feel, and we could take, subject to your convenience, a hearing in the week from any date from the 20th of this month.
And we need time to get the witnesses. Some of them will be coming from Meru, others from Kericho, others from Nandi. We require 21 days to be able to comply. Then we can take a mission date to take directions as provided.
We're still of the view 21 days is too far for a matter filed last year. It must be remembered, this is the petitioner's case filed last year. We must have sight of why the High Court said this matter should be disposed on priority. If I recall the language, it was immediately. It was the hardship. The ex parte orders in the other suits are causing the respondent. So whereas I'm alive to the reality that the times are really at the discretion of the court, I must still remind the court, we must still work with the possibilities of the very draconian orders issued, should not have issued in the first place. So I'm only beseeching the court, even if we get a time next week,
are now more clear with the pleadings around be able to deal with the nitty-gritty that are set out here. So that compliance should not really be a big problem. That you agree, but I think you said you have
I've requested 14 days. My colleague talks of 21. The difference is 7 days. So if we could share the 7 days, I would be happy. We can come the first week of July. That will give.
Can we do 14 then?
Yes.
Is that okay?
That's
Fair enough.
14 for it?
Yes.
14.
Perhaps you could get what dates are available from the courts.